Mr. Vannepoel.
As the court pleases, Honourable Justices, I appear on behalf of the respondent with my learned colleagues Aisha de Wet and Esma Ritz. Thank you.
Thank you, Mr. Kutsia. Mr. Vannepoel.
May it please the Court, Justices. This appeal concerns absolutely no dispute of fact. All the facts are indeed common cause, as was stated by this Court in its earlier judgment in the 5 cases, which included this one dated 31 March this year. It is only an issue of the interpretation of Section 11(1) small f, for frank in brackets, that is in issue and in dispute between the parties. The question is therefore solely one of the correct interpretation of the relevant statutory provision. That question is in essence whether fully refined gold in one of the 8 prescribed forms supplied by the appellant to Absa, the bank. One of the 3 listed recipients, those being the South African Reserve Bank, mint a function. It aligns with legislative purpose and commercial reality. It distinguishes manufacturing that creates consumable goods on the one hand from refining, which is allowable, that restores gold to its investment grade bullion form. We say that is the reading that makes the statute as a whole, but more in particular, Section 11(1)(f) work. It's also from a comparative, this is the third theme of our 30-minute address, from a constitutional and comparative perspective. It's mindful to know that the Value-Added Tax Act in our jurisdiction did not emerge in isolation. It's based on the New Zealand Goods and Services Tax Act, and it is aligned with the OECD model VAT guidelines and the European Union's directive. Each of those foreign regimes treats investment-grade precious metals as zero-rated financial commodities, taxed by reference to their purity and form, and not by their provenance, historic condition, manufacture, or anything else that happened in its prior life. We say that our Section 11(1)(f) uses virtually identical language as that contained in the GST Act of New Zealand and in the European Union Directive. On the Commissioner's version, however, 2 chemically identical bars of gold being supplied today to a bank, both 99.5% pure, must be taxed differently because bar A contains gold originating from a previous process of manufacturing, historically, because it was contained in an earring. But bar B comes directly from the mine. We ignore for a moment the manufacturing of the Doré bar. Bar B qualifies for zero rating, and thereafter, and unfortunately, bar A, you are disqualified as a consequence of historical manufacturing. We say that's absurd. And if one takes it one step further, what will happen thereafter is Bank 1 that purchased bars A and B in my little example would forever and a day not be able to sell bar A at the zero rate because it must be flagged for containing gold that was previously part of a process of manufacturing. We say that's also absurd. One will never be able to police and regulate that type of situation. If it qualifies insofar as purity and form is concerned, the requirement and intention of the legislature, we respectfully submit, have been met, and it ought to be zero-rated because it assists with VAT neutrality and it causes a situation of non-cascading of VAT. We say that 3 propositions, all grounded in the record, support our reading. Firstly, the text itself permits refining and manufacture of gold forms. The language presupposes prior transformation, otherwise there would be nothing to refine. Secondly, the purpose of the section is to maintain VAT neutrality and to align our country with international practice. Thirdly, Section 11's contextual harmony, we submit with respect, demands that all other zero-rated provisions serve to maintain neutrality in trade and finance and not to distort it. That's how it's to be understood, I beg your pardon. So we say that it is a current and forward-looking provision, and it does not require one to look back into history. Also, if one has regard to the previous BCRs of 2013 and 2019, the binding class rulings, SARS's contention is, but listen, Lueven, appellant, although you were a member of the class there, the ruling in itself, at its sharp edge, did not concern the question whether a zero rating is permitted in the context of scrap gold acquired, refined, and eventually supplied in the form of pure gold bar. Perhaps it did not, but what was practiced by SARS, pursuant to those binding class rulings, was done on the basis that absolutely every single iota of a fact was conveyed as part of the binding class ruling application, contained in those binding class rulings themselves, and the interpretation of the respondent was in accordance with what the appellant currently contends should be the correct interpretation. In those circumstances, we say that SARS's construction, which yields uncertainty, inequity, and irrational discrimination between identical commodities, cannot be constitutionally, with respect, sustainable. And in those circumstances, our submission concludes by saying we submit this is a case not about the chemistry of gold, it's about the architecture of the Value Added Tax Act, and that a sensible interpretation, understanding, and application of Section 11(1)(f) ought to result, that makes sense in the circumstances and that is possible to be applied by the partakers in the refining industries, by the mines, by the acquirers which form part of the closed list of recipients to make the Value Added Tax Act work. Importantly, this is not an exemption. No favour is done to the supplier, the appellant Lueven, in these circumstances. It is a zero rating provision. Section 12 deals with exemptions. It is a fully vettable transaction at the rate of 0%, and it ought to be entitled to claim its input tax deductions in those circumstances, and the recipient should not be burdened with paying VAT on top of the purchase consideration, but it should be zero rated. We submit with respect that the Court of Quo incorrectly accepted the say-so of the respondent to the effect that the purpose of Section 11(1)(f) is to benefit mines, and we submit respectfully that the respondent's overly technical and focused textual interpretation is incorrect and is divorced from reality, and it does not align with the purpose of the legislature, the context of the provision itself, and of course not even with a correct textual interpretation of the section. In those circumstances, we will respectfully request that the appeal be upheld, that the orders of the Supreme Court of Appeal, insofar as it's still necessary, and the Court of Quo be set aside, and that the relief sought in the notice of motion, bar prayer 2.2, which has been jettisoned in the Court of Quo proceedings already, that those be granted, and we'll request respectfully for the costs of to counsel to be granted in favour of the appellant. Those are our opening submissions. May it please the Court, Justices.
Thank you, Mr. Swanepoel. Let's just look at the section. You don't have a problem with the first and the second part of Section 11(1)(f), that is the supply of the gold to the banks and the Revenue Bank.
We have no issue with the wording. May it please you, Justice Mhlanta.
The issue really is the part commencing which has not undergone any manufacturing process other than the refining thereof or the manufacture and production of such parts.
Certainly, Justice Mhlanta, that is the issue up for adjudication.
Okay. Now, just for my understanding, you said this provision is forward-looking.
May it please you, Justice.
How is it? If you could just explain.
May it please you, Justice. What we say is, in the BCR rulings of 2013 and 2019, the Commissioner, pursuant to Section 11, subsection 3 of the Value Added Tax Act, which provides that if you want to zero rate, you can do so, but you must satisfy the Commissioner as to which documentation he requires to be satisfied. And the Commissioner, in terms of those binding class rulings, said, I need one document only, the tax invoice, please. Had the Commissioner then already perhaps thought that it was necessary to turn one's head and, so to speak, proverbially look back into the history of the gold, where it comes from, what potential processes historically of manufacturing it had undergone, he would have said, listen, give me a certificate of origin or something of the kind. Explain to me, where did you get your Dore bar and who made input of the gold substances contained in the Dore bar, not fully refined, that you delivered at Rand Refinery for final refinery. Why? Because I want to be satisfied with respect there's not an old earring contained in that gold. It wasn't the requirement. So we say it's illogical, impractical, and quite impossible to investigate historic origin of gold. It simply cannot be done. It was never done. It has never been practiced by the Commissioner. It does not form part of the binding class rulings. The documentation required by him never asked for this. But moreover, the provision itself must be borne in mind. We are dealing with a supply of goods. It would be the first time, respectfully in our country's history, that a value-added tax supply of goods is to be treated not on what is put on the table as part of the supply, but an inquiry is now to be made as to the previous condition of what is contained in the gold bar to determine its vetability, whether it's standard rated or zero rated. It's just impractical and impossible, and we say it does not align with the totality of the structure of the VAT Act. What is on the table is supply, supply, supply. You look at what is supplied.
Okay.
Absolutely nothing else. The injunction is this. The legislature wanted an unmanufactured product. But if the legislature stopped there in its wisdom and in its wording contained in the subsection, any potential supplier would be in dire straits and say, but I can't supply you anything that has something that has never been manufactured. So give me a form.
Okay. Let's just look at these words, which has not undergone any manufacturing. I know you've told me about
Yes,
this happening, but let's look at the provision itself, which has not undergone any manufacturing process other than refining thereof or manufacture or production.
Yes.
We know the applicant is a trader. It buys scrap gold,
Yes.
buys, and then it takes it to a refinery for processing.
Yes, Justice.
In that case, would we not have two steps of manufacturing process? Because initially you have the jewelry, which has already been processed.
Yes.
Then that jewelry is taken to Rand Refinery for another process.
Yes,
So there are two processes there.
Yes.
Now, that process or those processes, how do they fit into this provision?
Thank you, Justice Mhlanta. We say not only two potential historic processes of manufacturing, but multiple historic processes of manufacturing may exist in the circumstances. And that gold, when eventually contained in the correct purity and in the stipulated form, will qualify for zero rating. The answer with respect, Justice Mhlanta, to your question is those processes which constitute historical manufacturing has zero bearing on the zero rating provision whatsoever. It matters not. We say because the legislature sought that what must be supplied must be unmanufactured, but he can't stop there. He must now regulate form. You can't say, supply something that is unmanufactured. That's physically impossible. Textually, that's also impossible. One cannot think of something that can be a goods or a good and has to be supplied without being manufactured. I couldn't think of something, and none of my juniors could either. But the very same legislature that wants, in its wisdom, that the goods must be unmanufactured, he says it must be unmanufactured, but I'll give you 8 forms. Nothing beyond that. If you add to that, if you vary that in any way whatsoever, cannot be subject to zero rating. So we say that those historical treatment or manufacturing processes applied to the gold in the form of jewelry or for whatever other purpose contained in the hardware devices of computers and so forth, it matters not, because that is not what is supplied. What is supplied on the table today is a 99.5% gold bar. And no supplier would ever be able to supply gold that had not previously undergone a process of manufacturing, including the mines, because the mines, we know, cannot dump their ore with trucks at Rand Refinery's facility. This case has been made in the founding papers. It's undisputed. They provide, what they do is they partially refine, they manufacture Dore bars, D-O-R-E, with a little strippy on the E, and then they deliver that at Rand, and they say, please refine to 99.5%, this must be delivered to Absa Bank Limited. Those processes of prior manufacturing ought then to also exclude that supply from zero rating. May it please you, Justice Mhlanga.
You look at the end product, which is the 99-point-something% of pure gold after this process.
Justice Mhlanga, yes. Respect, if I understand the proposition in question correctly, what we say is that the goods to be considered is the goods on the proverbial table being supplied today, not what is inside the gold bar and whether it at all in its prior life, after being extracted from the crust of the earth in the form of ore, becoming a doré bar, etc., final refining at Rand, and whether or not in that interim process it underwent other manufacturing processes. That can never be the situation. It's divorced from a reality to interpret the section in that way. And also, there's no cogent reason to do so. What can the reason be? SARS doesn't really say. And we say it can serve no purpose to do it like that. It will be unpoliceable. No documentary process would be able to exist that can regulate what is contended for by the respondent. May it please you, Justice Mhlanga.
Now, if your interpretation is correct, why are the 8 permissive forms of gold listed twice in this provision?
Yes. What we say is, if you read the provision, firstly, it provides that the supply is to the 3 listed recipients of gold in the form of, and then all 8 forms are stated. And then the word which appears. We say, correctly, textually, the which should be understood to refer to the gold already in existence in those forms. And then the legislature, as we know, what the legislature deems necessary is to have an unmanufactured product to be supplied. It must be unmanufactured, so-called investment gold. And then what the legislature in its wisdom did is not repeat the totality of what appears earlier in subsection 11(1)(f), but he says, which has not undergone any manufacturing process, and then the prohibition, other than the refining thereof, or the manufacture or production of such. And the such, we say, with respect, refers to the bars being supplied on the day of supply, at the time of supply. Such bars, blanks, coins, ingots, buttons, wire plate, granules, and solution. What we say is, the phrase is cast in the present tense. It is not looking backwards. We say, what is out is gold that has been manufactured, cannot be supplied. Its form is not just regulated, it is expressly stipulated in the latter part of 11(1)(f). We know the legislature wanted to be unmanufactured, but that's impossible, so he stipulates the form, one of the 8 forms, and that's why it's contained there. It makes the section effective and able to work in practice. May it please you, Justice Mhlanga.
Well, Justice Kolape?
Sorry, Mr. Swanepoel, just for my clarification. I'm not a gold person, so maybe you can explain this to me. In response to Justice Mhlanga's question as to what would constitute the practical implications of a forward-looking provision, you made reference to SARS requesting tax invoices which didn't require historical information.
May it please you, Judge.
I'm not sure if that answered my question, because I was wanting to ask you a similar question. It would seem that the zero rating comes into effect at the time of the supply, correct?
May it please you, Justice Kolape.
So the act of supplying is not contentious,
May it please you.
and what is to be supplied to qualify for zero rating is not contentious.
May it please you. We submit that it is not, Justice Kolape.
So at that point in time, you either qualify or you don't qualify for zero rating.
May it please you.
If you qualify, then you would have satisfied the requirements of the section, in that at that point in time, the only allowance that the section created is that the final product would have been refined or manufactured, correct?
It must be manufactured. The allowable manufacturing is in one of the 8 forms.
Right, good.
May it please you.
So from that point in time, what would be an example of how the Act would have a forward-looking effect?
Yes.
what kind of activity would be excluded then?
Yes.
Because the supply has happened. I mean, you've reached the point when the bar has been manufactured.
Yes.
The ingot or the blank coin has been manufactured.
Yes.
What can be then forward-looking?
The only forward-looking step that can notionally, in my respectful view, Justice Colopin, exist is after manufacturing, there is a moment that passes and then there is a supply. From here to there, looking forward, what is eventually supplied must be in the stipulated form and nothing else. It answers two questions. One, it gives the direction of the forward-looking nature, what we submit should be the case of the provision. And secondly, it also answers this court's question directed to the parties after the 31 March this year judgment, namely, what other potential processes can there be? We've listed in paragraph, I think, 64 of our heads, a reference to 46 other potential forms, etc., etc. Anything that is not stipulated would constitute unallowable manufactured products. We know the legislature requires what is to be delivered to be unmanufactured. But he can't stop there, the legislature. He then says, I'll allow 8 forms, and you have it.
Legislature allows you to manufacture or to refine, not so. Doesn't
Refining is manufactured. I beg your pardon, you're correct, Justice Colopin. Refining is allowed expressly.
and manufacturing is allowed as well.
It's certainly allowed, and that, may I just pause for a moment, Justice Colopin, with your permission, that refining is not restricted at all by any textual reading or a contextual understanding of the subsection to be allowable only in respect of gold that had not had a prior life in the form of perhaps being part of jewels.
Does it not exclude those other manufacturing processes, but one that led to the production of gold bar?
We say that it
Do
does.
that, because if we accede to your interpretation, it would really mean that when I bake a cake and I use flour that's been refined in a mill,
Yes, Justice.
the manufacturing of the cake, if I could call it that, and that's probably the wrong term,
Yes.
includes the manufacturing of the flour, whereas I'm not responsible for the manufacturing of the flour.
Yes.
Would it not give the section a hollow meaning?
We say not. We say that at a textual level, it makes complete sense to know also when you interpret what the legislature demanded, where the phrase comes from. It has its origin earlier in the Mining Rights Act, and it continues to exist more or less in exact terminology in the Precious Metals Act. The legislature seeks something to be not manufactured, unmanufactured. And then if, using your example, Justice Colopin, if I may attempt to give it a go, if there was a prohibition against the flour, having had a previous life, then of course it would be something very difficult to establish, to police, to establish origin, provenance, etc., etc. There would have been other documentary requirements. One would have to ask, but for what potential purpose can that be? And if on the day of supply, it has always been the case in our jurisdiction that what is supplied is looked at, evaluated according to form and purity, and if it qualifies, it's zero rated. The historic existence of what is contained within the parts of that supply has never ever been considered, and would also, of course, from a value-added tax perspective, be absolutely irrelevant, because then thereafter there would be other regulatory requirements that banks, before they can on-sell some of their gold bars, must distinguish between the so-called standard-rated bars that they acquired, because it's always tainted, if I may use the term, and the zero-rated bars, and it's just impractical.
Okay, thanks. All I want to say is that on a plain reading of the section, it contemplates that there could be multiple manufacturing processes. There could be multiple manufacturing processes.
Certainly, Justice.
And it seeks to desegregate historic processes.
We submit, if one reads the second leg, there is absolutely no textual indication that it could notionally apply to something that has happened historically, because it refers to the gold that is being supplied in its existing form.
Okay,
May it please you, Justice.
Yes, Mr. Swanepoel, if you have paragraph F in front of you.
May it please you, Justice.
I can ask you to assume that the paragraph had ended after the first listing of the 8 forms and hadn't contained the part which starts which has not undergone. Assuming we cut out from paragraph F everything that starts at which has not undergone.
May it please
Your
you.
interpretation would that truncated paragraph have any different meaning to the one you are advancing to us? Because, of course, to supply bars, etc., gold in the form of those things, one would have to manufacture, and if the banks so require, you might have to refine.
Certainly.
So there's inherently a process of manufacture and refining to get them into the form. And so if we put our full stop at the end of the first listing of the 8 paragraphs, what on your interpretation does the rest of the paragraph add?
Yes, Justice Rogers, if one has to answer that question, and one has to also, as part of the reasoning and response to the question, divorce oneself immediately from all context and potential purpose of the provision, there's certainly an argument to be made that it could be understood immediately after the first description of all the gold bars, that that is what must be supplied.
No, I'm just asking on your interpretation. Let's just call it the second part of the paragraph.
Yes.
Does the second paragraph in your interpretation add anything
Yes, it
to the first part?
Yes, we say that it does because what it does is it closes the totality of the indication what the legislature requires, namely unmanufactured gold to be supplied, and then it also indicates and stipulates what the legislature allows as part of that manufacturing, namely 2 processes, 1 refining and 2 manufacturing, but then the regulation follows immediately, it must be form limited.
But either the gold that the supplier to the bank supplies is in one of the 8 forms or it isn't.
Certainly, that's correct, Justice Roger.
And you say if it is in one of the forms, it is 0 rated.
Certainly, Justice.
And inherent in the fact that it is in one of the 8 forms is that the person has refined it and manufactured it into one of the 8 forms.
Yes.
So, in other words, refining and manufacture, to the extent that it relates to the 8 forms, is inherent in stipulating the 8 forms.
Certainly, it must be so, Justice Roger.
So, as I come back to my difficulty, and I'm not sure you've confronted what was underlying, I think, the questions so far from my colleagues, but I put it in a slightly different way. Unless the manufacturing process in the second part envisages something other than the process that is inherent in producing gold in one of the 8 forms, it is meaningless. It adds nothing to the interpretation of and the effect of paragraph F, which is, to put it differently, and I think my brother Colopin asked this, it doesn't help to refer to a passage in your submissions which refers to a whole list of other forms in which gold might exist. The lawmaker doesn't have to accommodate that because then it wouldn't be gold in one of the 8 forms. Either it is or isn't gold in one of the 8 forms. So unless you are to render the second part of paragraph F meaningless or nugatory, you have to be able to identify as some prohibited form of manufacture which is not inherent in the manufacture of the 8 forms. Because, of course, if it's not in the 8 forms, you don't need to disqualify it because it wouldn't fall in the paragraph in the first place.
Yes, I understand the question, and that's also the manner in which the question by the court was phrased to the parties, bearing in mind that the exemption, i.e. 0 rating in any event, applies only to refined gold in one of the 8 forms.
And if, in fairness, just so that, I mean, I did study the submissions that were made, and I personally have not yet grasped what process of manufacture, other than the production of the 8 forms, is envisaged here on your interpretation.
One has to, I respectfully submit, perform the exercise of interpretation not only at a textual level. One has to have regard to context and purpose. One has to have to ask the question, where does the wording come from? The wording of Section 11(1)(f), where does it originate? Where does it come from? One sees it comes from the Mining Rights Act. It was transferred also and utilized almost exactly like that in the Precious Metals Act.
If I can stop you there,
May I please?
I accept that one might want to go to broader context and the philosophy of VAT, and I must say I always struggle to some extent with the notions of VAT being a tax on consumption and being paid by the ultimate consumer. I'm sure that's the philosophy, but ultimately we must have a look at what the lawmaker says. I appreciate that the philosophy may affect our interpretation, but ultimately we must look at what the lawmaker has said. Is your answer to my question that the second half adds nothing, but we must accept that because that's more in keeping with the philosophy of the Act?
The response might not be too palatable once I've given it.
Might not be?
Too palatable to the listener with respect once I've given it, but we say that it's not redundant because it is the regulating part of the provision. It allows refining, it allows manufacturing, and it sets the extent thereof. I understand.
But you've accepted that merely by conferring the zero rating on gold in one of the 8 forms, that's already incorporated into that.
Potentially
So
that
the
can...
lawmaker on the face of it in the second part is disqualifying the zero rating if there's some other process of manufacture. And it seems to me you have not yet given an example of what would be prohibited on the forward-looking process, and your interpretation, unless you can persuade me otherwise, effectively says we must treat the second part as, I don't know, some form of repetition or reinforcement, but as not adding anything, and we should tolerate that because that's more in keeping with the principles of that.
May I add to my response the following, with your permission, Justice Rogers? If one has to explain from a textual interpretative perspective the second part of the passage and the reuse of the prescription of the 8 forms, one answer can be that, as the Supreme Court of Appeal held in the matter of CONSHU, C-O-N-S-H-U, 1994, 4SA on page 603, when the legislature uses tautology, a device often used, it is to emphasize what the legislature might want to say. And then, of course, we say that if one understands and interprets the text contextually, one arrives at the point where one has to answer the question, where does this term come from? Is it a technical type term, or is it just normal words used in here? It's very technical in its nature. And is it redundant or not? And we say that it can certainly not be redundant for 2 reasons. One, there is a clear statement as to what is allowed, refining and manufacturing, and the extent of the manufacturing is stipulated. So the refining is okayed, if I can put it in that term, and manufacturing is also stipulated and regulated, despite the fact that what the legislature wants is an unmanufactured product. It wants unmanufactured gold to be supplied. But is that notionally possible? We say, of course, it's not possible, but the legislature gives the remedy immediately. It says it might be in one of these forms. You're allowed to do refining. I don't limit refining at all. You're allowed to do manufacturing, but that is limited to, I beg your pardon, one of the 8 forms only.
I don't want to be unfair to you, but just at least for my own understanding, my puzzlement may not be shared by colleagues. But when we come to write this judgment, can we accept that there is no prohibited form of manufacture on your process, on your interpretation, which is not already inherent in limiting the zero rating to the 8 forms?
A qualified yes, and I qualify the yes, Justice Rogers, respectfully, because if it is anything other than the 8 forms, it's out. So, in other words...
Anything other than the
one of the 8
forms is
forms
out anyway.
In any way, may it please you.
Thank you.
And if examples are asked, one has to have the appreciation that certainly the legislature understood that gold bars can exist in various forms. If one has regard to the report referred to in paragraph 64 of our supplementary submissions pursuant to the court's question and onwards, those forms are actually identified in there. It must be bars of a certain purity and a certain form. it's stipulated. There can be any other value added, and there can be further process or processes of manufacturing, but the lawmaker, we know, the legislature in his wisdom says, well, I've got a closed list of recipients, I want to benefit them. They appreciate the benefit of the zero rating themselves because they don't have to pay standard rated VAT. It is not a consumable in their hands, it's a value containing article or substance or good that they purchase to comply with other pieces of legislation, and therefore it would be unfair to pass the brunt of final consumption on them. That neutrality would not be achieved, and they would sit in circumstances where they have gold bar A and gold bar B in my previous example, and they would forever and a day be prohibited from selling gold bar A at the rate of 0% because it contains an old nose ring or earring or whatever the case may be, or a wristwatch or whatever the situation is. And that is just absurd in the circumstances, especially if one has regard to the context. So our submission is respectfully that the second part of 11.1F is not redundant. It emphasizes what the lawmaker wanted. It makes it clear that the lawmaker wanted no manufacturing process to have been, the 8 forms, well, the gold must not have been subject to a manufacturing process. And that part of the second part is not a repetition. Because where the words appear, which has not undergone any manufacturing process, they appear there for the first and only time. And it's the indication that the legislature in its wisdom decided it must be unmanufactured gold, but then to allow there to be a circumstance where there's no uncertainty and clarity, he then says, but your manufacturing can be in one of the forms. That's as simple as that, ma'am. Please you.
Yes, Majid?
Thank you. Mr. Swanepoel, I want to ask you about something that I struggled with in your submissions. I must say, let me just preface my question by saying this. I share this sort of disquiet that my colleagues have raised with you with the interpretation. But if you look at your written submissions at page 45, paragraph 117, you reference Nissen versus CIR. Now that, I looked at the case and I couldn't quite square all of it. Because there you make the submission that based on that case, there's a certain sequence that must be followed when we construe tax statutes with words like such and so on, as also occurs in section 11.1F. Can you, or maybe later one of your juniors, find me a passage or passages in that case which bears out what you say here? Because I really struggled. I looked at the case, I couldn't find it.
I please you, Justice, I will do so. The submission at its core there, insofar as the reference to the word such is concerned, if I may, with your permission, Justice Majid, just say this. The contention, of course, is that the utilization by the legislature of the word such in section 11.1F can be nothing other than a reference to the goods forming the subject matter of the supply, i.e. the gold, which must be unmanufactured, but in one of the allowable manufactured stipulated 8 forms, and can never be taken to be a reference to the historical gold as contemplated by the respondent in its interpretation. That's the extent of the reference to what we submit respectfully ought to be the correct understanding of and interpretation of the word such where it is contained in the subsection. But certainly we'll have a look at the Nissen judgment, and if there's anything positive to come out of that, we'll reference it in our reply. May it please you, Justice.
Now, secondly and lastly, again in your written submissions, I mean, I only found this in a footnote. It's like a throwaway line almost. Footnote 177, you say, page 48, you make the point that one must have regard to the Constitution, of course, section 39.2. Then comes this, read with section 24 of the Constitution. You say the latter entrenches environmental rights and requires legislative measures to secure ecologically sustainable use of natural resources. Was that pleaded anywhere in the papers, first of all? And secondly, can you elucidate that submission for me?
By way of elucidation, the core of the submission, and I'll make double sure that I don't mislead by saying now it's contained in the founding papers, but I'll make double sure and revert to that. But the core of the submission is this. If the respondent's contention is to be accepted as the correct interpretation and application of section 11.1F, Justice Majid, One knows, of course, that then what would follow is that only newly mined gold would be capable of being subjected to a zero-rated supply, despite the fact that there already is a historic manufacturing process, namely the creation of the initial doré bar. But if one ignores that for a moment, one then knows that gold, newly mined gold, is a finite resource.
To interrupt you, can you please edify me? I'm not au fait with any of this. What is a doré gold bar? Can you just explain?
What is referred to in the founding affidavit, Justice Majid, is that the process followed by mines that mine ore is that they are not permitted, and this is common cause between the parties, to deliver the ore at Rand Refinery for the comprehensive refining into the eventual gold bar, one of the 8 forms. They perform in-house partial refining, and then they in-house create or manufacture what is referred to as a doré bar. And those doré bars constitute the form in which the gold, as it exists at that time, not fully refined, is delivered by the mines to Rand Refinery. And after that initial process of manufacturing, Rand Refinery takes it, fully refines it, and delivers on behalf of the mine what constitutes the supply to, for example, the banks. So those doré bars, we say, over and above the fact that they constitute a process of manufacturing, which should also eliminate banks from being able, I beg your pardon, mines from doing zero-rated sales of gold. The situation there is that if the legislature, who knows that gold is a finite product, could, in accordance with the respondent's interpretation, only allow newly mined gold to be sold to the 3 recipients. Firstly, it would stifle instead of incentivize the supply of gold to the closed list recipient members. And secondly, it would infringe upon potential constitutional, environmental, and other sustainability considerations, because it would mean that the supply of the gold will eventually run out. May it please you.
Yeah, I must say, where I come from, I'm more familiar with diamonds. But, so you say that not only textually, but also purposefully, bearing in mind the Constitution and ecological or environmental considerations, yours is the preferred interpretation.
We say
for
so.
the reasons advanced.
May it please you, Justice Majid.
Yeah. I'd really love to have those passages and listen. I think I may have misread the case or just not speak it up. Thank you.
May it please you.
It's wonderful. Thank you, Justice Matlanta.
Justice Majid, may I just, with the assistance of 2 of my juniors, the reference to finite gold is to be found in Annexure LM29. It's on page 118 of the record. I think that's in volume 1. And paragraph 6.4. And then also in the replying affidavit, paragraph 10 on page 236. I'll again double check that myself and revert to it if necessary, Justice Majid, in my replying argument. May it please you.
Mr. Swanepoel, just to continue on that question that Justice Majid posed to you, the argument regarding Section 24 in the Constitution is raised for the first time in this court. It was not raised previously, is that right?
Justice Theron, I'll double check on that. But the fact that a finite resource is under consideration in terms of the respondent's contended interpretation, that was, to the best of my knowledge, raised in the founding papers already. And what we submit is, in any event, Section 39.2 of the Constitution...
Was that point, I'm sorry to interrupt you, raised and argued before
we submit
in another court?
We submit that it was argued in the court of proceedings, yes.
It's dealt with in the judgments.
It's not dealt with in the judgment.
Is there anything that you can show us that it was raised in the SCA?
The SCA did not, of course, pronounce on the merits, and I'll
My question is,
understand.
raised in the SCA,
May it please you,
you
Justice.
can show us that it was raised in the SCA or in the High Court. And
If you will afford me that
those
opportunity,
courts.
if you would afford me the opportunity, I'll do so in my replying argument. May I just add, as part of my response with respect, Justice Majid, that Section 39(2) of the Constitution imposes a duty, of course, on the Court to interpret the Act with reference to the Bill of Rights, and which includes Section 24. But I'll certainly make sure that I direct your attention to where and when exactly, if it was argued in the Court or in the SCA proceedings, Justice Theron, where it was done.
Yes. In your written submissions, as well in your argument today, you've referred to the Precious Metals Act and the Mining Rights Act. How do those acts help us understand and interpret Section 11(1)(f) if neither of those acts is concerned with tax revenue?
Yes. What we have attempted to explain in paragraph 64 and its subparagraphs on pages 25 and 26 of our latest written submissions, Justice Theron, is that simply with reference to the question, where does the phrase come from? Where does the wording originate? The submission in paragraph 64 is that the forms of gold listed in section 11(1)(f) resemble similar lists contained in related legislation. The legislature variously refers to such forms as unwrought or unmanufactured in legislation like, for example, the Mining Rights Act and the Precious Metals Act. And we say, if you have regard to those subsections, that is made clear there. And then, of course, we make the culminating submission in paragraph 65 of our heads of argument, namely that this court has held that where different statutes deal with similar subject matter, they should be construed together and harmoniously. I immediately recognize, Justice Theron, that those acts do not deal with the imposition of standard-rated or zero-rated value-added tax, but it does assist to understand where the legislature obtained the wording from and what the intention behind the particular use of the wording is. It is twofold. First, it is in unmanufactured form, but those 8 forms contained in 11(1)(f), when one reads the second part of 11(1)(f), constitutes what the legislature decided in its wisdom to allow, despite the fact that it requires the gold to be supplied to be unmanufactured. May it please.
Understand the relief that the applicants are seeking. It is seeking declaratory relief
May it please you, Justice.
from this court, providing a definitive interpretation of the meaning of section 11(1)(f. Is that right?
May it please you, Justice Theron.
So why would the 2-class rulings then, why should we rely on the 2-class rulings? This court is being called upon to make a declaratory order.
Yes. Justice Theron, what the 2-class rulings, binding class rulings, reveal is that for a decade, the Commissioner for the South African Revenue Service was aware of all the facts pertaining...
Sorry to interrupt you. What the class rulings show is the opinion of somebody.
May it please you, Justice Theron.
Yes.
Yes.
Now, this court has been asked to make a declaratory order.
May it please
So
you.
this court must interrogate section 11(1)(f. Is that not so? And the opinions of others can in some instances be helpful and in some instances they're not.
Certainly.
I struggle with your argument that the provision in section 11(1)(f) is forward-looking, particularly if one has regard to the words that are used, which has not undergone. Those words, they specific and they apply to the past tense.
Justice Theron, we say that the interpretation, which has not undergone any manufacturing process other than refining thereof or the manufacture or production of the gold in one of the 8 forms, is not a historic consideration. We say it's not past tense. We say it's manifestly in the present tense because it refers to what is being supplied and not the historic condition, for 2 reasons.
What's it saying? I'm sorry to interrupt. I'm
Mate,
just
please.
mindful of time. It says, what is being supplied must not have undergone.
Yes.
how can that be forward-looking?
Justice Theron, what it says is, it regulates form. If one reads the second part of the subsection, Justice Theron, it starts with the words which has not undergone. It certainly cannot refer to something that is not being supplied. If that contention is to be upheld, if that is held to be correct, it must refer to what is supplied and not a historic form of the gold contained in the bar. And secondly, it permits two things. Firstly, refining. We see, therefore, that the lawmaker knew that refining or manufacturing ought to have been allowed. And refining contemplates a prior existence in another format. And what one sees there, despite the text and the potential possibility to say, but is it not backward looking into a historic condition, one sees there the lawmaker, the legislature did not say refining only of newly mined gold. He just did not say that. Refining is allowed in its totality. May it please you, Justice Theron.
Thank you, Mr. Swanepoel.
May it-
Justice Mhlanga.
Just to follow up on that, why, if it's a future-looking provision, it's forward-looking, why would it say which will not undergo any manufacturing process?
Yes, Justice Nichols, we say that if one has regard to the underpinning consideration from a value-added tax perspective, it has to do with what is supplied. In other words, one puts the proverbial goods on the table and looks at it. And one says, insofar as substance and form, purity and form concerns, does it qualify, yes or no? One does not say that one performs an investigation into something that is not on the table and look at a prior life 50 years ago, whether or not a part of what is contained within what is supplied had a prior life which included some other form of manufacturing. Had that been the case, as I've explained earlier, and I apologize for repeating myself, the creation of the Dore bar would, on CSARS's interpretation, constitute a prior process of manufacturing. So not even mines would be able to provide it as such. The form is merely stipulated and thereafter it's regulated, despite the fact that what the lawmaker wants, what the legislature requires, is something to be supplied that must be unmanufactured.
But you don't seem to be able to identify any future manufacturing process that could possibly be referred to, or am I incorrect?
If I say a future manufacturing process, it contemplates anything that will take or will cause the gold supplied to be anything beyond the stipulated forms. In other words, if any other value is added. And as we say in paragraph 64 of our heads of argument, there we give examples of leaf bars, round bars, square bars, various different potential forms. They are still called bars, but what we say, therefore, is that if value is added as part of what is being supplied, it will be out. So that is something that can only occur after the initial coming into existence by way of manufacture of the allowable forms, despite, with respect, Justice Nichols, the requirement of the legislature that it wants something unmanufactured to be supplied. So if it's a manufacturing process beyond refining or beyond manufacture or production of the bars, then it's disqualified from zero rating.
I'm not sure I fully understand, but I'll leave it there.
Thank you, Mr. Swanepoel.
May it please you, Justice Mhlanga.
We will take a tea adjournment. We'll adjourn for 20 minutes. Thank you.
So, Annelie,
Quickly, once more, let us be ready. Thank you.
Mr. Kutsia?
As the court pleases. Justices, I'm not going to be long. I've got a very short opening address. What is important to start off with is that it's agreed that the time of determination whether the supply qualifies for zero rating is at the time when it's supplied to the closed list of recipients. That's a determination stage. Furthermore, 11.1 in the intro says, where but for this section, a supply of goods would be charged with tax at the rate referred to in section sub 1. So in order not to be to have that levied at a standard rate, you must meet the qualifications of section 11 and specifically section 11.1F to qualify for the zero rating. So everybody accepts that there has to be a disqualifying manufacturing process, which is a manufacturing process which has not undergone any manufacturing process other than the refining thereof or the manufacture or the production of such bars, blanks, coins, ingots, patterns, wire, plate, granules, or solution. So to postulate a process after the supply as a process that is disqualified in this section is a non-starter. Because it's what happened, the determination is made when the supply is made to the closed list of recipients. Now, the court, when it posed its question, was aware of the respondent's case and aware of what the court or quo found to say this was a historical manufacturing process. And then posed the question, providing the appellant an opportunity to identify any manufacturing process that is forward-looking that would disqualify a zero rating. There is no qualifying forward-looking manufacturing process that they've been able to identify. So if there's no forward-looking manufacturing process, the only logical one, which if you take into the words used in the Act, is the historical manufacturing process. Therefore, it is a respondent's submission that there are no disqualifying manufacturing processes other than the historical manufacturing processes, and we respectfully submit that the interpretation of the court of quo is correct, and also in this regard. Now, the issue raised by Justice Rogers, I'd like to address, if I may, in my opening address. The appellant's case is that section 11.1F must be interpreted that if gold in one of the 8 specified forms is supplied to one of the specified recipients, the supply must be zero rated. in the heads of argument, they say nothing more, nothing less. Now, the point raised by Justice Rogers is basically you stop at subparagraph 1. And then the entire, if that was the intention about the way that this section should be interpreted, there's no need for the remainder. So it would then read, such supply of goods shall be charged with tax at the rate of 0% where the supply is to the South African Reserve Bank, the South African Mint Company, or any bank registered under the Banks Act of gold in form of bars, blanks, coins, ingots, buttons, wire plate, granules, or in solution. That's where it stops. The proviso that disqualifies certain supplies of gold does not emanate from a permissible manufacturing process. So then you ignore the proviso that says which has not undergone any manufacturing process. It's not referred to at all in the interpretation. The appellant also can't explain why the second, call it the second clause, or the clause that's got the provision that identifies what manufacturing processes are excluded. The interpretation makes this clause entirely redundant, of no cause and effect, or of no meaning. In light of the nature of the supply, to postulate a manufacturing process post the supply to the banks, which they're attempting to do, makes no sense. It can only refer to a historic manufacturing process. We respectfully submit that the appellant has not responded to the question posed by the court. Instead, it raises in its heads of argument that the postulate of why the question was posed by this honourable court was whether the second sentence, the duplication, is a duplication of the first sentence and whether it is redundant. The second phrase, the qualifying phrase, has to be given meaning. The first phrase deals with the permissible forms of gold to be supplied to the three recipients, and the second phrase disqualifies certain supplies of gold that do not emanate from permissible manufacturing processes. Now, the other issue is this in pare materia, or the reliance placed on the Mining Rights Act, the Precious Metals Act, and the Exchange Control Act, which is relied on. And said, in the heads of argument, the following submission is made. For present purposes, it suffices to revert to the Mining Rights Act and Precious Metals Act. They too, just like that Act, draw no distinction between newly mined gold in unwrought form and gold that has historically been subjected to the manufacturing or refining process, but again in unwrought form. They need this because the appellant contends that these acts do not distinguish between newly mined gold and second-hand gold, and Section 11F should not draw such a distinction. These acts are not para materia. They do not contain the phrase which has not undergone any other manufacturing process, which is the subject matter of the interpretation. This honourable court, in the Swanepoel case, dealt with the impera materia and how it should be approached and applied. In the Swanepoel case, you had legislation relating to short-term insurance and the Medical Schemes Act. and the sections were similar. But you can't just grab any section and import it into another act. In paragraph 91 of the judgment, the following is raised. In general, as found by this Honourable Court, in general, it is understood that in pare materia on the same subject, rule is of some persuasion, and I emphasize, when an identical provision is found in a statute that is similar in object, purpose, and subject matter to the one being interpreted. Now, in the Swanepoel case, they were similar. It had to do with medical aid insurance and short-term insurance. The acts that they're trying to compare, the VAT Act, are totally different. VAT Act is a revenue legislation. The acts that they're referring to regulate proceedings totally unrelated to anything addressed in the VAT Act. And secondly, it has no similar provision to the disqualifying provision in section 11(1)(f). Now, the strongest argument advanced, but is the weakest argument of the appellant. They try, and it's not a good argument factually, nor in law. Because you say the facts don't bear it out and the law doesn't bear it out either. They say, but SARS always interpreted the Act the way we want to interpret it, or the way we interpreting it. And they did so for many years in a binding class ruling, and they should be bound by this interpretation. Well, obviously in law we cannot be bound by this interpretation because it's a court that must interpret the Act. So that is on a weak foundation. Justice Tron said, but if that opinion is wrong, it is wrong. We must express an opinion on the interpretation of the section. We say that doesn't even come to the fore because the binding ruling most definitely does not give an interpretation that the appellant is advancing. And we say, therefore, the binding ruling has no previous interpretation that aligns with what's been alluded to by the appellant, namely that all gold supplied in the prescribed form without qualification or without disqualification qualifies for a zero-rated supply. The binding ruling is not an interpretational document. The binding ruling deals with the simple section 11.3 of the VAT Act. What documentation is required? Now, the biggest issue for a normal taxable supply situation claiming an input or an output is the issue of a tax invoice. In light of the nature of the supply, the gold from the mines that emanates from the mines is deposited at Rand Refinery. There's commingling, and Rand Refinery is merely an agent for Lueven and others who delivers to the commercial banks in this instance. Now, there's no tax invoice that can be issued and say, well, this is the gold that we go to Rand Refinery, and it's exactly the same gold that's been supplied to the commercial bank. And because of that issue, they said that there's certain documentation that Rand Refinery issues, which is sufficient to meet the requirements of the supply and the documentation in terms of Section 11(3) of the VAT Act. There is not a single statement or shred of evidence in the binding ruling that can ever be interpreted to say that the gold should not have undergone a previous manufacturing process as described in the exclusionary phrase, because it's not referred to in the binding ruling. That is not the purpose of the binding ruling. Previously, the appellant advanced the statement that the binding ruling also relates to recycled and secondary gold. Today, conceded that the binding ruling makes no such reference. The binding ruling clearly indicates the depositors of the gold are the mines. So the other issue, and I'm not going to go into it in much detail, in our heads of argument, we took the declaratory relief sought prayer for prayer and indicated why that declarator is impossible to give. And today, I thought my learned friend would have gone outside the declarator and said, well, we're looking for something new today. Today says I want exactly the same declaratory relief as set out in the notice of motion. If you look at the notice of motion, just for example, 2.1 as an example. In 2.1, the case is basically the present notice of motion are to be found in volume 1, page 1.1. In relation to 2.1, the word gold in section 11.1f, it wants to be interpreted to be 99.5% or whatever, as per the contract with ABSA. Obviously, you can't use a contract to interpret the statutory provision, and it makes no sense. If you just bear with me for a moment, there's one. And unless the court requires me to do so, I'm not going to deal with the other declarators in the detail that we dealt with in our heads of argument. Our heads of argument basically say, this is what they're asking for. It is impossible, then we say why, and then we deal with the manufacturing process and we answer the question posed by the court. So, in conclusion, we respectfully submit that on any interpretation of section 11.1f, the disqualifying manufacturing process or the permissible manufacturing process, you've got the manufacturing process, the goods have been supplied in the correct form, then the question is, was it exposed to any manufacturing process other than that process, the permissible process which would disqualify it? That can only be a historical manufacturing process. Furthermore, my learned friend says that you don't vet the supply there's nowhere in the VAT Act where you vet look where the supply emanated from. There are provisions of this nature in the VAT Act. The one that comes to mind is the various provisions that relate to notional input. Notional input looks backward. From where does the supply originate? What documentary proof is there to prove that it comes from a member of the public? So you have to prove from where the supply came from, who the person that supplied it, and do you qualify to get the notional input. The other issue that I don't think my learner is not entirely accurate on my understanding of the definition of second-hand goods in the VAT Act is that gold is included in the definition. If I remember correctly, I'm speaking out of memory now, is that presently it's in the Act on the basis that the gold must be supplied in the same form onwards. That's, I think, but it does refer to gold. The history of gold and being included at stages, it was included in the definition of second-hand goods, and stages excluded. My recollection is that it was excluded at a stage, and then various parties that wanted to be able to claim VAT, etc., on second-hand gold made certain representations, and it was put back. But nothing really turns on that. I have no further submissions to make at this stage.
Mrs. Swanepoel, no, I'm sorry, Mr. Kutsi. Apologies. I just want you to help me. Mr. Swanepoel seems, if I understand him, the important part of this provision is the fact that the jewelry or gold would have been refined. And they are looking forward. They say you want us to look forward. And the fact that it has been refined and the end result of that is pure gold, 99%. Then they will fit in. One should not look at what has happened. How does that fit in with what is provided in the section?
It cannot fit in with what was provided in the section. It can never fit in with what's provided in the section because the section clearly says there's a supply to the closed recipients of these forms, then you go, which has not undergone any manufacturing process other than the refine or manufacture of the specified forms. So there is no basis on any construct for that interpretation. It makes no sense.
Justice Rogers?
Mr. Kutsi, can I just understand the practical implications of your interpretation? I perfectly understand the linguistic process of interpretation. If a gold mine refines the gold into bars which are at a relatively low level of purity and sell it to likes of Lueven, is that an ordinary vatable transaction?
No.
You say it isn't?
No, it is a normal vatable transaction, I apologize, yes.
When I say vatable, not vatable at zero.
Yeah, I understand, it's standard rate, yes.
It's 15%. If Lueven, assuming such a bar was sold directly to Lueven and it then further refined it into a form that was acceptable to ABSA, for the moment I accept that the definition of gold doesn't have to follow ABSA's requirements or these recipients' requirements of purity, but as in fact it may be that ABSA requires it to be purer than the form that the gold mine refines it to. So if Lueven does that and makes a, say, a 99.9% pure bar and sells it to ABSA, is that, it won't be zero rated because the gold mine itself has already manufactured a door bar?
No, that is incorrect. Because if you look at the section, which has not gone any manufacturing process other than the refining thereof. So there's been a partial refining by the mine. So long as the only process that bar that you're speaking about, my lord, has been exposed to is a refining process, it is not a disqualifier.
All right, so that would then depend on a question that isn't before us, which is whether the refining thereof can include refining done by some predecessor in title. Because, of course, the refining thereof would not, in our example, have been done by Lueven.
No, but so long as the refined bar hasn't been exposed to a historical, impermissible manufacturing process, there's absolutely no problem.
And I then infer from your answer, although it's not the question before us, that, of course, what the gold mine has is ore with bits of gold in it. It puts it through a production process, smelts it. It doesn't just, one can never supply formless gold.
That's
To
good.
some extent, it is the fact that it's not only refined, but put into the form of a bar, a low purity bar, not a process of manufacture.
Well, Lord, that is a partial refining process. The Doré bar will come from the mine, and a Doré bar is in form as fine. And there's a partial refining. There's nothing to prevent that refining. And if underlying this principle, and I'm not saying this to change, we say that it's permissible and it doesn't affect the equation and the interpretation, because you can refine as many times as you want to, so long as it hasn't been exposed to a disqualified manufacturing process. And this must also be seen in the basis that when Rand Refining was brought into existence, it was to take supplies from the mines. If you look at the binding ruling, it says to get deposits from the mines. So everybody knows that the source of this gold is mined, And it's mine gold that gets the benefit of this favorable tax dispensation. And when I'm saying the fact that it's put in a doré bar because of partial refining is not a limitation and will not make any interpretation incorrect.
All right. So, of course, Mr. Swanepoel in reply may say, well, that's not the correct interpretation of what refining and manufacture contemplates, but your proposition is that the fact that a gold mine partially or refines and produces an ingot or a bar or plate that is refining within the meaning of the section.
Yes.
And it isn't excluded manufacture because there's a difference that you can refine, but then you put it into a form. And I think the argument will be that putting it into a form as an ingot or bar or plate is itself a process of manufacture, and that if your argument were right, in our example, Lueven would be hit by the fact that the gold mine had manufactured the plate or ingot.
What's important in what I'm trying to put across is which has not undergone any manufacturing process other than the refining mill. So that gold, it's more extraction process, but this extraction of the gold going through a partial refining process has never been exposed to anything other than a refining process, and we say it doesn't fall foul of the section.
And that in regard to the manufacturing, and I can see the argument also in regard to refining, and I can see the argument also in regard to manufacture. But remember, it's the manufacture or production of such bars. In our example, that's the bar supplied by Lueven, not the bar supplied by the gold mine. So it would be said that if Lueven manufactures a very pure ingot bar, it has done some form of manufacture, but that's permitted.
Yes.
Your opponent would say, well, that means the gold mine itself has undergone a process of manufacture. It's just manufactured a less pure ingot or bar.
But
and on your argument, nobody other than a gold mine could ever benefit from this provision.
And anyway, ingot is a permissible form. It's a manufacturing process that gives rise to an ingot.
Yes, but an ingot created by the gold mine is not the ingot that's being supplied.
Correct, my lord, but the situation is, if an ingot has been produced, there's no problem. The disqualifying, if it's in the specified form, it's fine. No, if that manufacturing process gives rise to a specified form, it's not a problem. But if that manufacturing process gives rise to a second-hand gold jewelry or jewelry, that's where it's struck.
Anyway, the bottom line is that on a part of the section which perhaps mercifully is not up for declaratory relief in this court, you say that when a gold mine's supply of partially refined gold in some sort of lumpy form, whether it's a bar or a plate or an ingot, is not falls within the permitted refining and manufacture that the section contemplates.
Correct.
So on that footing, if Lueven and their similar firms buy all bars directly from the mines, they will be all right?
Yes.
Or through an intermediary. Yeah. But once the gold mine's bar or product has undergone manufacture into an electronic item or jewelry or whatever, then you say it falls out.
Then the problem arises.
Thank you.
I have just one question, Mr. Coetzee. What is meant by certain forms in the explanatory memorandum?
So what is meant by?
Certain forms. The explanatory memorandum uses the phrase certain forms.
The certain forms are the specified forms in section 11, and that explanatory memorandum is basically just a recording that it's a zero-rated supply. It is not a detailed explanatory memorandum that is explained in the section. It just says this is what the section says and what its effect is. You can't get anything from it.
That's my question. Does the memorandum, does the certain forms in the memorandum specifically relate to the forms prescribed mentioned in section 11(1)(f.
It doesn't say so directly, but by implication, that's what I'm saying. It appears that's what they're referring to.
Yes, thank you, Mr.
Colleagues,
Thank you.
thank you, Mr. Kutse.
Thank you, Justice.
A reply, Mr. Swanepoel.
May it please the court, justices. May I start with the textual consideration, and in particular some of the questions that were addressed to me earlier. If one has regard or considers the question whether from an interpretative perspective it is at all possible to say that the second part of section 11(1)(f) may be regarded as redundant, our answer is emphatically that it is not redundant. The first part, if one reads the wording, specifies form or shape. That's all that it does. The second part is not a mere repetition of the reference to the 8 allowable manufacturing forms. It also describes what is referred to in the legislation as the unwrought, unmanufactured nature of those forms of gold. So the first part describes shape or form, and the second part only is the part that describes the unmanufactured, or to use another word, unwrought, required condition of the gold. The point is made more elaborately in paragraph 64.1 and 64.2 of our supplementary written submissions. As regards the question posed by Justice Rogers to our learned friend, but insofar as it concerns the manufacture of the doorway bar by the mine, doesn't that constitute a previous form of manufacture? The answer was given by Justice Rogers as to what the opposing argument from the appellant side would be, namely that the wording of the section cannot be ignored. The allowable bar to be manufactured is not the doorway bar, it is the bar for supply. If it was not so, of course, then the word such would not have appeared there, but there's a more compelling reason even, and that is that value-added tax and the imposition of the zero rate, fully vatable at the rate of 0% tax, considers nothing other than the supply of the goods intra-transactional on the day after those goods have come into existence. Therefore, our submission that it is not a backward-looking interpretation that is required if one has regard to section 11(1)(f). Of course, my earlier utilization of the phrase that it is forward-looking in nature does not contemplate anything to happen in the future. It contemplates that intra-transactional sale of the bar by Lueven, the appellant, to the bank, i.e. the one and only supply. It does not concern historic evaluation of the matter contained in the gold bar and whether or not so-called prohibited, if I may use the phrase, gold is contained in there. We say that, of course, it's only the current supply that is of relevance if one must answer the question whether or not the sale should be vatable at the standard rate or vatable at the rate of 0%. Nothing other than the current supply. Our learned friend contends that the appellant has not answered the question as to what other potential manufacturing process can come into play. If one is mindful of the fact that the first part of subsection F considers shape or form, and the second part considers condition, namely the unwrought, unmanufactured condition, one realizes that a plate can be anything in the form of a plate, but one must also have regard to accompanying applicable at the moment legislation such as the Precious Metals Act, which regulates the validity or lawfulness of the possession of a plate of gold. We're not considering here a Christmas plate of gold. It is the specified, regulated form of gold that is allowed to be possessed by a licensed recipient of the supply that is under consideration. So anything that would change it from that into, by way of adding value to what has been manufactured, will of course be disallowed. And that is what is provided for in the second part of subsection F. In those circumstances, we respectfully submit that the contention by, or on behalf of the respondent, that the other manufacturing processes have not been identified is wrong. We do so in particular in our heads of argument at paragraph 107 and more particularly paragraph 114 with reference to the Grandin International Research Report that is referenced in paragraph 117, which identifies various additional shapes, etc., outside of the scope of the regulated, lawfully able to exist shape in the possession of the registered recipients contemplated in section 11(1)(f). Over and above that, we say that if one has regard to the explanatory memorandum, and the wording of the explanatory memorandum is quoted in our supplementary submissions in paragraph 71, it is the supply of gold in certain forms to the Reserve Bank or a registered deposit-taking institute that is zero rated. Yes, those forms are not elaborated upon in the explanatory memorandum, but those forms, i.e. the shape, is described in the initial part of section 11(1)(f), and the unwrought nature thereof is specified in the latter or second part of section 11(1)(f). Insofar as it concerns earlier questions by Justice Majid, and my indication that I will revert as regards reference in the founding papers to the finite nature of gold, it is referenced in the annexure LM29 on page 118 of the record in paragraph 6.4. This is the response to the audit finding letter already, and also in the replying affidavit in paragraph 10 on page 236. Insofar as the environmental submissions and reference to sections 39 subsection 2 of the Constitution of the Republic of South Africa and section 24 is concerned, we say there that of course if one has regard to this court's case law in the matter of Phumelela gaming, even if not pleaded by a party, a litigant is entitled to refer to section 39(2) of the Constitution, and this court will always, as part of its interpretational exercise, consider the spirit, purport, and object of the Bill of Rights to be taken into account, and it should always be borne in mind. We also say that, with respect, the court quo, in its judgment to be found on page 275 of the papers in paragraph 8.16, erred when concluding as follows, and I quote, "In conclusion, I mention that in any interpretative exercise, the supremacy of the Constitution and the rights contained therein must be acknowledged, but no constitutional principle is offended by the interpretation under debate in this matter." End of the quoted part. We say that interpretation is always constitutional and must always be constitutional in nature. It always bears in mind the Bill of Rights and the relevant provisions of the Constitution. In those circumstances, we say that if one has regard to the relief sought, it is not objectionable relief as such. Essentially, the relief is culminated in prayer 2.4 of the Notice of Motion, and it is the declarator to the effect that what is not under consideration in the circumstances here is indeed prior historical manufacturing of the goods. Prayer 2.4 is on page 3, and it reads as follows: "The phrase 'which has not undergone any manufacturing process other than the refining thereof or the manufacture or production of' in section 11(1)(f) of the VAT Act refers to any manufacturing process carried out by the vendor supplying gold to the 3 recipients and does not refer to any process or processes to which gold may have been subjected historically. That would be sufficient, we say, in the circumstances. In those circumstances, we persist with the relief sought as set out in our heads of argument. Those are our arguments in reply. May it please the court, Justices.
Sonnepoel?
Please the court.
Mr. Swanepoel, you referred to, I think, is it Annexure 29, in response to the argument that the finite rate nature of gold has been raised. What does Annexure 29 say, please?
The annexure, Justice Theron, commences on page 109. The specific paragraph referred to is on page 118. It is in volume 2 of the record. And paragraph 6.4, gold is virtually indestructible and lends itself well to recycling. It should be noted that jewelry accounts for nearly half of the total above-ground stocks of gold. Scrap jewelry constituted more than a quarter of the world's gold supply during 2019. In contrast, underground gold reserves and resources are finite. Remaining gold reserves are estimated at approximately so-and-so, compared to a total approximately so-and-so tons of gold ever mined. In the taxpayer's view, paragraph 8.5, it was not the intention of the legislature to place a time limit on the relevancy and application of Section 11(1)(f) by restricting the application of the provision only to newly mined gold. And then it continues thereafter. May it please you.
Please describe what document is that, Annex 29? Who was it prepared by?
Yes, it's written by the attorneys representing Lueven. It is addressed to the South African Revenue Service and its attorneys, and it constitutes the formal response to the letter of audit findings.
So you say that is sufficient to raise the constitutional question of Section 24 in this matter?
We say that even absent the reference to Section 24 ought still to be taken into account if one has regard to Phumelela Gaming case law by this Honourable Court. But yes, that is what we rely on to make the point that it has been referred to as part of the founding papers, may it please you, Justice. It was not expressly stated.
So an annex that's attached to the founding affidavit is sufficient to raise a constitutional point?
Justice Theron, certainly it's not ideal if it's only in an annexure, but the constitutional element involved here and the context of the consideration of the finite nature of gold forms part of the interpretative exercise when one interprets the provisions of Section 11(1)(f), which includes the consideration of the finite nature of the gold. It is not the primary hook upon which the appellant, of course, wants to hang its coat or its hat in the circumstances of this case, but our submission is that it does not constitute, with respect, Justice Theron, irrelevant matter or an absolutely irrelevant consideration.
My concern, Mr. Swanepoel, is whether that point is before the court and whether it has been properly raised. That is my concern.
In the replying affidavit in paragraph 10, in paragraph 236, on page 236, it is in volume 3, on behalf of the appellant, the following was stated by the deponent in paragraph 10 in the second sentence. If the respondent's contentions are to be upheld as correct, which the applicant denies, it would have severe implications for the SARB, Mintco, and registered banks, who would no longer be able to source newly refined gold at the required purity level from any licensed supplier, including the second-hand jewelry and scrap gold industries, as an investment item at a zero rate, and would be obliged to source only newly mined gold from local mines in order to gain the benefit of a zero-rated supply, bearing in mind that gold is a limited, finite product. This notwithstanding that a practice has developed over a period of more than a decade where zero rating was consistently allowed and accepted as correct by the respondent, as stated in the applicant's founding affidavit.
Now, is it proper to make out a case in reply?
No, certainly it is not. But as I have submitted with respect, Justice Theron, and I can't take it further than that, the exercise of interpretation of legislation involves a constitutional consideration.
Now, so I'm sorry to interrupt you.
No, please.
What constitutional right is the applicant seeking to enforce? Is it seeking to enforce Section 24?
May
I'm
please-
trying to understand the
If one-
constitutional argument.
If one considers Section 24 of the Constitution, it provides that the environment must be protected and conservation must be promoted, etc., etc. The point that is made in the annexure and also in the replying affidavit is merely to say that as part of the interpretation...
Sorry, can you answer my question, please, Mr. Swanepoel? What right is the applicant asserting, and who is infringing that right? And in what manner is it being infringed?
The respondent's interpretation would have a manifest bearing on the infinite nature of
What right
gold.
is the applicant asserting in this matter, Mr. Swanepoel?
There's no infringement of a right being infringed, asserted in the founding or replying affidavit, Justice Theron. It's merely saying that the interpretative exercise should bear in mind that gold is a finite resource. That's the extent of the submission.
Yes, thank you, Mr.
May it please you, Justice Theron.
Thank you, Mr. Swanepoel.
May it
I
please you.
think your junior wants to end with something.
If you would grant me a moment. The Nissen page references, I beg your pardon, Justice Majid, I also indicated earlier that I will provide those with reference to the word such and its contended correct interpretation. It appears in footnote 16 of our heads of argument and in the Nissen judgment at page 869 at C, and then also in footnote 20 of our written submissions and in the Nissen judgment at page 870 at B. May it please the court, Justice.
Thank you to counsel. The judgment is reserved. Court adjourns.
And that's when, I'm standing there. And I don't know who thinks she's a presiding officer. She thinks So how do we know now that this people's hangouts?
Guys, it might be rolling.